So just to make sure we stay on time, we'll start. It's my pleasure to introduce the next panel, which is sentencing. I'm going to start with my friend Anna Trbovich, who is moderating this panel. Anna is a staff lawyer at the Court of Appeal for Ontario. And in that role, I know her because she organizes the administration of all the review board appeals. So Anita, Anna and I work closely together and trying to figure out all the quirks. And then beside her is Justice Brock Jones. Justice Jones sits in Toronto on the Ontario Court of Justice. And before that, he was an assistant Crown Attorney in Scarborough. And last but certainly not least is Amy Shoemaker, and she is the director of the research department at Legal Aid Ontario. So we look forward and thank you all for this next panel.
Well, thanks very much, Dina. Can everyone hear me okay? Thumbs up. Excellent. Thanks for the warm welcome. Thanks for creating this panel. So we're focusing into the sentencing realm. Warm welcome to these wonderful panelists. We're going to jump right in. And I'll throw this one first to Amy. What must be shown for mental health to be considered as a mitigating factor on sentencing?
Well, it's a pretty straightforward test in a way, except I feel like it may be a little less straightforward looking at the husband's case recently, as my brain was hurting this morning, kind of looking at that a little bit more closely. So the test was actually set out in a case called Priorello. And in order for mental illness to be considered as a mitigating factor in sentencing, the offender must show a causal link between his illness or her illness and the criminal conduct. So basically, the illness, is the underlying reason for the conduct. And that's sort of the first aspect of the test. And then the second aspect is there must be evidence that a lengthy sentence would have a severe negative effect on the offender, such that it should be reduced on compassionate grounds. So those are the two basic sort of points. And that was articulated in Priorello, which ironically was a case where the causal link was not found, which I think is kind of ironic that this is one of the cases that's cited, and yet in this particular case, it wasn't accepted. There's an earlier case I also commend to you called Batiste, which was an Indigenous lady who kidnapped a baby from a hospital. And the same basic test was articulated there, and there was a discussion about the sort of principles of restraint. In a more recent decision that has kind of clouded the waters, I don't think so, but we'll see. In the husband's case, which is the Eaton Center shooting case, there was an appeal in 2024. And one of the arguments that the accused made in that case was that there had been a failure of the trial judge to properly consider mental health issues as a mitigating factor for his sentencing. And he argued that he had PTSD and that he was suffering PTSD at the time of the shooting. And, that was a very dramatic and I guess horrendous case. I mean, there was many people involved. It was in the food court at the Eaton Center. And in that case, he got into the weeds a little bit on the test. And I have to admit, I found it hard to parse out a little bit. Because in this case, the trial judge actually found that the PTSD was not the sort of cause of the shooting, but it was something that was underlying, and it impacted, provided really kind of circumstances around, it gave some context to the shooting. And so they got into a bit of an argument in the case about the terminology in the case law. So Priorello was the case that was cited. But there was an argument, there was another case that Justice Durno decided, a case called ACKT, and there was a position taken in that by the appellant that basically they were requiring a direct causal link. The trial judge was requiring a direct causal link between the mental illness and the act. It's funny because then you look at the discussion and there's a reference to a demonstrated link. So now we have these three different sort of terms that are being bandied around, kind of in conflict with each other. But essentially the court determined, the Court of Appeal determined that actually they felt the Priorello test had been followed, and they really didn't give credence to the argument. The other interesting aspect, though, is that the accused in this case also talked about the issue around evidence demonstrating the sort of impact of the mental illness if the person was incarcerated, and he felt that that had not been tendered. And the court actually, again, kind of glossed over that issue, in my opinion. This is just my opinion, but actually said, well, the Supreme Court has said that we can actually look at mental illness really more broadly and consider the fact that it's reduces culpability and blameworthiness. So one of the things I would say about sentencing in relation to the mental illness and the impact of that on sentences, I see sort of a series of themes. One of them is restraint, the sort of principle of restraint and the importance of considering that. I think that you can also look at the issue of the fact that denunciation and deterrence are reduced, and really the focus is on rehabilitation. And that's really what the courts should be looking at closely in these cases. The other issue of the impact of the incarceration on a mentally ill offender, and the fact that, potentially they're experiencing a much harsher incarceration. I think that's a very valid argument, and maybe one that hasn't been well explored or is being explored in the case law a little bit more. And I mean, we've mentioned the book repeatedly, but the chapter in that book on sentencing and criminal law goes through some of the cases. One of the areas I think that there's a lot of ability to make arguments on is really around conditional sentences, and arguing for conditional sentences for offenders, because there's quite a bit of case law now, and the amendments that have come through in the code that have kind of widened the availability of conditional sentences makes this an area, I think, that there could be lots of creative arguments made now. In the past, there were a lot of statutory bars to imposing a conditional sentence, but now the door is opening. And even last night I was Googling around looking at, some cases, and I see even very recent cases where, for example, for sexual assault, conditional sentences being granted, where I saw several cases where there were people that suffered from autism and quite serious mental issues, and they were granted a conditional sentence. So I'm going to pause for a moment, lest Justice Jones say something.
I think you said it all.
Sorry.
I'll just add this. When we're in provincial court and we're in a busy plea court, or I'm in Gladue court or mental health court, we can have lists, 300 lines, 400 lines, okay? Every one of those cases represents a human being. In my assessment, we have to be careful about taking too rigid an approach sometimes to the causal connection between evidence of an underlying mental illness and the moral culpability of the person that I ultimately have to sentence. Because to not give weight to a recognized mental illness, right, and expect too much of a scientific basis, say, of connection between that illness and the particular offense could also result in a great injustice, where a sentence that is, quite frankly, disproportionate to that person's moral culpability is ultimately held down. So in these far more serious cases like husbands, I understand the great level of analysis that's applied, of course, as it should be. But one thing I would highly recommend to defense counsel in particular is, in these busy courts, tell me about your client. Tell me what you know about them and their mental illness or diagnosis or whatever it is that's affecting them. And then try to explain to me as best you can, perhaps through what your client has told you or anything else, how the connection can be made. Again, you will not always have the benefit. We'll talk in a moment about the tools that are available to counsel to draw, perhaps through an expert opinion, this bright line connecting the two. But that doesn't mean there isn't still a place for effective advocacy there to explain to me how this human being ended up in this position, why they maybe acted in the way they did, and how I can factor that in my view, lawfully at the sentencing hearing, right? Keeping in mind, of course, that hearsay that I accept is admissible in a sentencing hearing as well. So maybe I'll hold off on the rest till we get to the next section, but.
Oh, brilliant. And just we have the author of that amazing chapter in the book, the anthology is sitting, it's Amy. So I recommend the chapter. It's full, it's like a gold mine of material. You'll also get a handout after the cases that we mentioned by name. We've got the base cases in our handout, and then from them, you can find the like spin-off cases from there. So flowing to the next question. So we've talked a bit about how do you connect mental health to a mitigating factor? How can counsel and or the court obtain this information about the accused person's mental health during the sentencing phase? And I'll start with you, Justice Jones.
Okay, so I know this can be very challenging. Obviously, if you have a client with means, then you can retain a private expert if you wish, get that report, and then decide how much of that you disclose or share. Where that's not realistic, there are certain other options available to counsel. Okay. For adults under the Mental Health Act, reports can be ordered under sections 21 and 22 of that statute. At least in Toronto, I find that this is usually done with the assistance of the Crown's office through the Centre for Addiction and Mental Health downtown, and that a doctor can be assigned to produce one of these reports and usually produce them, in my experience, within 4 to 8 weeks, depending on if the accused is in or out of custody and some other factors. Keep in mind that report will come to the court and to the Crown, so you don't have total control over it if you're defense counsel, but they can be quite helpful. If it's a Youth Criminal Justice Act, Section 34 is available to order a report at any stage of the proceedings. There does not have to be a finding of guilt, so of course they can be ordered for the purpose of sentencing. In some cases, you might wish to consider, if you want to approach a judge in youth court, to order one of those reports even pre a finding of guilt, recognizing that the contents of the report will be given, again, to the Crown Attorney's office, but there are restrictions in the statute on what use the Crown's office can make of it, i.e. can't be used to incriminate the accused at his or her trial. But perhaps sometimes, and when I was a Crown, this would happen often, we get these reports and it would change my whole perspective on what to do with the case. And in some cases, you might even be able to obtain diversion, for example, or extrajudicial sanctions or whatnot. So these are just things to consider in the particular cases. Obviously, a pre-sentence report can be ordered, and they're not authored typically by mental health experts, but there might be some information that comes out of that that can also be helpful. But sort of, going back to what I said in the first section, do not be afraid as defense counsel. And I really highly encourage you in those cases where it just maybe isn't possible to obtain one of these reports, or the amount of time it might take to do so would result in your client being in custody longer than you think they should be, especially if the Crown is offered time served or near time served, or even if they're on very restrictive bail and you're very concerned about the possibility of a breach just because they're struggling to follow the conditions. Simply to interview the accused or other sources and then explain to me in court, what you've learned from where, what is it that you understand about your client, and how do you see it all coming together? And of course, don't lose sight of the right of allocution from the accused, who can tell me directly about anything that they wish to. And in my view, that's something I have to consider as well. I'm always loath to discuss one of my own decisions, but I'm going to shamelessly do it today. Yeah. Just to put it out there to let you know, as an approach I took recently in a case called Chakasim that's on the Canley, et cetera. You can see it. I was in Gladue Court, 300 lines on the list. Okay. Every case that comes up, the very, very sometimes very vulnerable individuals who need to have their personal circumstances considered. And defense counsel did an excellent job about telling me about this person as a human being. They'd been diagnosed with a version of fetal alcohol syndrome at some point in their life, how they were struggling just with regulating their behavior on a day-to-day basis, et cetera. Nothing I'm saying here isn't in the written decision that I released. But in my view, I had to consider this because the Crown was offering time served, right? So to adjourn it to get a more formal report, in my opinion, would have resulted in an injustice, right? It was simply not going to be achieved any other way. But factoring all these things in that I learned about this person just through the submissions of counsel and the recollection of everything counsel had learned, and Ms. Chakasim spoke to me personally as well, in my view, dramatically attenuated her moral culpability for the offenses that she'd pleaded guilty to before me. And not only should I have considered that, I think it would have been an abdication of my responsibility as a sentencing judge to not consider that information, give it the weight that I felt that it deserved. So I'll say nothing else about that because I was obviously the judge who did it, but I throw that out there as just something to consider in appropriate cases. I find sometimes young defense counsel in particular will say to me, well, I don't have a report. You know, I don't have a doctor's letter. I don't have something of that significance. Okay, like that may be necessary, especially in very serious cases, or certainly preferred, but it should not preclude you from attempting to show me how this is relevant regardless, and especially in cases where, quite frankly, obtaining that is unrealistic potentially for a variety of reasons, right? And I think, you know, all of these tools that exist and these principles are important. I don't think we can ever lose sight of the fact that I am choosing what to do with a human being before me who is vulnerable, and I need to know as much about that as I possibly can.
I can't add anything to that, I don't think. I think that's great.
And maybe just before we go to our next topic, maybe we could just talk a little bit about the pluses and minuses of those more formal assessments, the section 2021, but also the section 34, which can have a unique positive collateral use.
Maybe from a defense perspective, what would you think? Would you advise someone to get one or not get one in some circumstances?
I can really speak. I know that we've had lots of requests in my office. So we do research for lawyers across the province in various, you know, on various topics. It can be from very serious matters, lots and lots of sentencing. So I would say that there are a number of times when we've been asked about the section 21 and 22 MHA reports and whether there's any risks associated there. And there does have to be some consideration, I think, if they can end up somewhere else down the road. These things have a tendency to find their way into other proceedings. And that's something that we've looked at a few times. We have some materials actually on the website. So people, if you are doing legal aid work, have a look. We've got a memo actually on section 21 and 22.
I will say this, one day when I retire, I'm thinking of writing a book called Accused People Say the Strangest Things, because you do get remarks in these reports sometimes when the client is asked, well, what do you think about why you did this? You know, some of the responses are surprising. So, you know, maybe a heart-to-heart with the client beforehand about, you know, the judge is going to read this eventually would be a wise thing without doing anything inappropriate, of course. But at the same time, the responses are often very honest as well. And quite frankly, always give me insight into in how the person was thinking at the time, or at least at the time they're being interviewed.
And on the positive side of things, being a former youth crown myself as well, a 34 assessment has a unique ability. You can have it bifurcated, and part of it that's sort of focused on the psychoeducational part can be used to support an IEP. Yeah. Completely outside and divorced from the criminal justice system.
Yeah, no, they're phenomenal. Youth Criminal Justice Act Section 34 assessments, at least those produced by CAMH here in Toronto. I don't think I've seen many from other places that author them. They're really, really fantastic and will often lead to opportunities for the youth to enjoy a sentencing disposition that they might not otherwise maybe have been looking at without one as well. Or the Crown's Office may show some benevolence in how they address the case. Wasn't supposed to be funny.
Keeping it spicy. Amy, the next one's for you. When might mental health be considered irrelevant or at least of diminished importance in the sentencing phase?
Well, it's interesting. There's sort of a couple of different points that I see in the case law. A lot of it arises out of Alberta for some strange reason. There's a case actually that I noticed that's when I was looking at this called Verwint, where there's a really good summary actually of examples of when mental health will be considered of diminished importance or will be less relevant. So for example, one of the things I disagree with a little bit, but where the offender does not acknowledge the existence of a mental disorder. And they actually cite there an Alberta Court of Appeal case called Onassay, which is a 2015 decision. I found it kind of funny because I actually was searching. I thought I'd like to find like an Ontario case that articulates that. And the very strange thing was that a lot of case law came up about people denying their mental illness, all CCB cases, which I thought was so strange. So, you know, I wonder if that is actually a very good point. That should be actually a reason why you know, mental illness should not be considered, that denial can be a sign of a mental illness in itself. But other factors that are considered, for example, are where an offender acknowledges the disorder but refuses treatment. And actually, Kugaraja is a good example of that. It's in the chapter, but it's an example where that was cited as a reason for the factor not being considered. Also, where an offender knows the act is morally wrong. That's another one that I kind of question a little bit, but that's been something that's been pointed out. I think that's strange because I mean, we have the NCR process. I'm not sure that we are getting into weighing of the moral aspects of it in the nature of this. So I take issue with a few of the points that are being argued. Another one that I wonder about too is where the disorder or illness can be effectively treated or managed in prison. You see that argument sometimes with medical conditions as well, where you were trying to argue that the person shouldn't be going to jail because they have a medical condition that can't be treated. I think there's lots of examples of people who are not getting effective treatment in prison, aren't getting medication for very serious mental disorders and are decompensating. And one of the things I think that would be a great thing to see from council is making some arguments kind of in line with the sort of harsh treatment of pretrial custody and seeking credit for that, in sentencing. I see an example of a case in Nova Scotia where they made that argument. A lady who was denied medication while she was being detained, and she got worse and worse and worse, and it was really tragic. And the medication was actually in the infirmary at the prison, but they just were not administering it, so she got worse and worse. So I think that would be a great argument to make. We make these arguments about other aspects of detention, like at Maplehurst, at Toronto South. There's so much case law on that, but why not make these arguments in that context? So one other point I would make though too is where the offenses are very serious and violent. I think that's an area where we start to see things where the mitigating effect of the mental illness is perhaps diminished. And I still think that it's worth, I've mentioned conditional sentences, it's still worth making arguments even for serious offenses that there should be a lower sentence, a lower custodial sentence applied even in those cases. So I think you try not to, discount that. If you don't ask, you won't get. So, try to be creative in that sense, always trying to apply that principle of restraint.
The only thing I would add is that, of course, the court does have to be satisfied that there is a link, right? Again, some link between the underlying mental illness or condition and the offense that was committed. And there are quite a few appellate authorities, certainly in Ontario and in other provinces, where that just isn't established. And even though the offender has a mental illness that you would otherwise consider to make them somewhat vulnerable, in those cases, it cannot affect the sentence just as a matter of law, right? So the quality of evidence will matter and the connections that can be drawn will matter, hence what I was trying to talk about earlier. Even if you give it your best try as defense counsel, but I'm simply not satisfied that it is legally relevant based on the tests that apply, then unfortunately, that's when we'll have to be given little or potentially no weight with the particular sentence that I have to impose for the particular offenses before the court. And sometimes I think that seems jarring to some lawyers in particular, like, Your Honor, my client has X condition, right? And it's affecting his life. But if I'm not satisfied, that's what caused the offenses. And there's just really little to nothing that I can do to apply that unless you can convince me otherwise, right?
Yeah, take a look at Priorello. That's a good example, actually, where they didn't find the causal link. And, there wasn't a formal diagnosis of schizophrenia. There wasn't medical evidence before the court, but they also found that, there wasn't a connection there. So there's a good example.
This one's for you, Justice Jones. So how can counsel and/or the court help to support the procedural fairness of sentencing hearings involving accused persons with mental disorder?
Okay, so when the accused person has counsel, I'm trusting that counsel has taken the appropriate steps typically to make sure that what they're proposing we do, whether it be a guilty plea or anything else, has been done with instructions and that they feel we're in a position to go forward. If I become concerned, I may ask questions, but generally speaking, I'm trusting that defense counsel are professional, that they know what they're doing, and that they have no reason to have concern that this can't go ahead as quote unquote it maybe typically would. Where we really run into difficulties, obviously, are with self-represented individuals, including I've had some people before me who based on the information I've received, may have a significant mental illness or other difficulty, but nevertheless have made the decision, as they are entitled to do, to represent themselves, right? So what do you do in these circumstances? There's a higher onus, I feel, on the court to make sure that everything's being done fairly and that they understand. And then in appropriate cases, I will consider the appointment of amicus, right? In my view, amicus can be used for a broad number of purposes now. I know that originally was the criminal lawyers case that went up to the Supreme Court. Since then, there's been further jurisprudence from that court and our Court of Appeal, which seems to imagine that amicus can be appointed and even take on a very adversarial role in appropriate circumstances. And we can provide you with some of those cases and links if people are interested. But certainly, where the court is concerned that something doesn't feel fair, does the accused person really understand what they're giving up, what the consequences of this decision are? Steps have to be taken, and it means we have to slow it down, and we're just going to have to do our best. And to the credit of the crowns that I've had on cases of this nature, I find they're often very concerned about this as well, quite frankly. But the worst thing that I can do is not make sure of that, and then suddenly have an injustice occur, and of course, almost certainly an inevitable appeal as well.
And Amy, did you want to mention something you were seeing that was potentially an intervention involving accused refusing to come to court?
Oh,
Or-
yes. We've had a couple of inquiries where there'll be a situation that someone's in the cells and they will not come up to the courtroom. And that's a very tricky issue because it actually engages lots of different stakeholders. And it's very tricky with court officers bringing people or putting their hands on people. It can be a very scary situation because you're looking at something where there's an intervention that can lead to something very dangerous or, that both parties are hurt, but worst of all, the vulnerable person who is in the cell and is paranoid about coming up to court isn't being seen. So I think there's actually a case I saw in Ontario. I don't have the citation with me today, but I will pass it on and maybe it can be forwarded to you, where there was that exact issue was being considered and some of the charter issues around whether you can forcibly order, whether the court can forcibly order the person to be brought up to the courtroom. A lot of judges would not want to do that. So I don't know if you can speak to any of that.
Well, yeah.
No, do you want to add anything?
No.
What we sometimes colloquially refer to as an extraction order
Yeah,
is a very, very serious thing to consider. Would never be done on the fly. Would have to have a lot of thought put into it. And I've had success often, of course, with remote appearances. Sometimes accused persons who don't want to come to court the old-fashioned way are nevertheless comfortable, maybe appearing remotely. Sometimes you have to build a bit of a rapport, right? Let them know that you really are genuinely interested in what they have to say and that their interests are being considered, and that can help. And then sometimes you just skip that day. And it's unfortunate to waste a day of court time, but if the accused person is not in a position maybe to do it, but they might be better in a week or a little bit longer or something like that, let's just slow it down, okay? Because there's no need to rush. And that particular tool that does exist in the criminal code, carries with it potentially significant peril for a lot of people, okay? The accused person, of course, but also the officers and everyone else, right? So
I'm mindful of the time and we were going to talk about diversion, but we've heard a bit
Mhm.
about it already with the specialized court presentation. Maybe I'll pick our first. We're going to address some questions that were submitted in advance. Maybe I'll stick with the first one.
Sure.
So the question was, in light of the science that the human brain isn't fully developed until early to mid-20s, why hasn't the WiCCD, the Youth Criminal Justice Act, developed a more comprehensive approach to youth? How can we as advocates essentially argue the WiCCD in reverse or like forward, however you want to conceptualize it for sentencing in 1 minute?
more like 45 seconds.
Woo.
This is what I would say. There's a case before the Supreme Court now on reserve on adult sentencing for youth. And I know that one of the arguments that was made in that case, okay, was about how much can a court take judicial notice of some of these features of adolescent development, okay? And doctors I've had testify in many cases will talk about how the human brain continues to develop well into one's mid-20s, especially those areas that are dealing with, risk assessment, judgment, et cetera, those kinds of things. Hopefully the Supreme Court gives us some guidance on that. In youth court, you've got the WiCCD and the principles and the jurisprudence that exists. I think you can be quite passionate as defense counsel in particular in that regard. But with adults, I'll just flag this. It's an excellent case from Chief Justice Tulloch from our Court of Appeal called Habib. Okay, it came out last year, and it talks about sentencing principles for young adults and how turning 18 doesn't magically bestow upon you maturity and wisdom of an adult of many more years. And anyone who's the parent of a teenager knows that's very true. But regardless, it's got great language in there about how we consider these factors with young adults, really 18 to 21, at least maybe a little bit older than that, depending on the person. And how some of the sentencing principles you might otherwise apply would be attenuated in these circumstances. And if you have a young adult offender, go to that case. It's just very well written and summarizes the law extremely well. I rely upon it all the time for what it's worth. I would recommend it.
We've made it under the wire.
That's right. It's just barely.
Thank you. A warm thank you to our panelists and thank you for this wonderful audience as well.